Good morning, all. This case management conference is in the matter of CFI 092-2024 and is being held by way of video conferencing before His Excellency Deputy Chief Justice Ali Al-Madhani, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Mayor Brown. Lead counsel is Mr. Gerard Moore. The defendants are represented by Aker Choket Advocates and Legal Consultants. Lead counsel is Ms. Jordana Dre. Thank you, Your Honor.
Thank you very much. You allow me for a minute. Good morning, Counsel.
Good morning, Your Excellency.
Good morning, Your Excellency.
Thank you for appearing today. Mr. Moore, you might lead the way.
Thank you, Your Excellency. My name is Gerard Moore. I'm a partner at Mayor Brown, and we are acting on behalf of the claimant in this case. The claimant is MAG Development Services Limited. It is part of the UAE-based family-owned conglomerate MAG Group Holdings. This is, in my submission, Your Excellency, a very simple case. It's a case about the defendant's breach of a lease and the claimant's entitlement to damages and its entitlement to terminate the lease for that breach. I'm pleased to say that so far as today's CMC is concerned, it is hopefully also a very simple case for you. We have a case management consent order, which is agreed between both parties, which provides for all of the pre-trial steps all the way up to and including the hearing of a 2 or 3 day trial commencing on the 30th of March 2026, subject obviously to the court's availability and orders.
But Mr. Moore, how you convince me it's a simple and straightforward case and then you end up with a 3 days trial? That does not make sense. Not at this court.
Well, that is, thank you, Your Excellency.
Lawyers cannot make lot of money here before me on the client's cost.
Yes. I would suggest it is a simple case from the claimant's perspective. The defendant will obviously have its own outlook on the complexity of the case. But as I said, perhaps I can give you a bit more context as to why I say this is a simple case, Your Excellency. So,
no, you need to tell me. You need to give me tips why it's complex. I understand it's simple, and I do understand the defense even, and then even the
sure.
That's cool. Yeah.
Sure. Well, just for some context, Your Excellency, these proceedings, they concern the premises on the 26th and the 27th floor of the Emirates Financial Towers. This is a property that's owned by the claimant, my client, and which the claimant leased to the defendants pursuant to a lease that was dated 15 August 2023. Now, this was a long-term 10-year lease from which the claimant expected equally long-term financial and commercial benefits. Under the lease, the defendants were obliged to and agreed to pay an annual rent of 5.25 million dirhams. And that rent was due to be payable in 4 equal installments of 1.312 million dirhams approximately. Now,
per annum, per year.
Per year. So a split equally in 4 installments of 1.3 million. Now, on the back of this long-term commitment, the claimant terminated a pre-existing lease, which it had with another entity, in order to make the premises available to the defendants. Now, it did so at a cost, quite a substantial cost. It incurred around 2 million in early termination fees, as well as a further 2 million in order to reinstate the premises for the defendants fit out. And the claimant incurred these costs on the faith of the defendant's long-term commitment under this lease. Now, at the time, the claimant understood from their long-term commitment that the defendants were serious business people with serious financial backing.
So
Now,
this is not Shilankur rent, isn't it? So it was based on certain preparation of the premises.
correct, correct. To turn it into the base fit out, so that the claimant could then, or sorry, the defendants, I should correct myself, could then add their own fit out for the club, which was a restaurant and private members club concept.
Their own fit out.
Correct.
What's your 4 million for then, Mr. Moore?
To remove the previous fit out from the previous tenant,
I see.
and then add the base fit out upon which the claimants, the defendants, I need to correct myself, upon which the defendants would then build upon that fit out. So it wasn't kind of shell and core as such, but there was a base fit out that was supposed to be implemented, or which my client did implement.
I see. And after all of this arrangement, then the defendant, how long they rented? 2 years?
It was a 10-year lease.
No, but how long they continued renting?
No, it was less than 1 year. So what actually transpired was that I mentioned before that the annual rent was split into 4 installments.
Yeah.
So the defendants only paid the very first installment in full. The second installment was only paid in part, and that was around, if my memory serves me correctly, only around 200,000 dirhams out of a total of 1.3 million. And then after that, the defendants failed to pay a single dirham in rent to the claimant. And so that's why I say this is a very simple case from my perspective, Your Excellency. It's simply a case for unpaid rent, breach of the contract, breach of the lease by the defendants. And at the moment that they failed to pay those rental installments, my client would have been well within its right to terminate the lease. And indeed, this is the fundamental truth about this case from the claimant's perspective. So the defendants will make submissions about force majeure and good faith and various arguments, and I can address those in a moment. But
You didn't have to go that far. I mean, yeah.
Your Excellency, if I may ask.
In your turn, please. In your turn.
Okay, all right.
yes, thank you, Your Excellency. And so, now, I was about to say, the defendant will make various arguments about good faith and force majeure when you hear from Ms. Dre. But the fundamental point is that the defendants were in breach of the lease before any of the events or circumstances they rely upon for their good faith and force majeure arguments. Now,
yeah. And I have looked at the case information in the memorandum as well. I mean, I thought you were thinking also in providing an expert, 2 witnesses plus expert for the quantum of the damages you're seeking.
correct.
Yeah.
Correct. So we will have at least one factual witness, probably one, but we've, out of an abundance of caution, made provision for potentially 2. But I think 1 is how many we'll have. And we're also going to have 1 expert to deal with the quantum of our damages in order to support those. So that will include the lost rent, obviously the costs incurred and which we've claimed by way of the early termination fees on the previous lease, the costs to fit out the premises after the pre-existing lease, and the costs that have been and will be incurred in order to carry out a new fit out post termination of the lease.
And how many witnesses the defendant bringing? I will come back to Mr. Dre, but Mr. Dre.
We are.
Identify 2?
I'm sorry?
You identified 2 witnesses?
3.
3? Oh, 3.
Yes.
3 in total.
Yes. 3 witnesses and 1 expert.
Okay, 1 expert. You're thinking of joint expert or a separate expert?
Separate experts.
The expert also for the quantum or for something else?
No, the expert is basically to give an overview and an idea of the cost and insurance of luxury cars and the damages this type of floods could cause to such a collection of cars.
Oh, I see. Okay. Sorry, I just invite you to jump into the last point, but I'm inviting you again to start wherever you went from.
Okay.
Yeah, Miss
Thank
Raya, you may say whatever you want in 10 minutes.
Thank you. Okay. So I'll be very short. To me, it's not that straightforward. I want to highlight a point that is for me crucial, that actually the claimant maybe missed or forgot to mention in the recap that was made in the memorandum. One of the key points that actually is a preliminary point in the list of issues is the question of the contract. Why? Because the position of the defendants is that the claimant failed to amend the contract, and therefore Mr. Laurent Buisine and Mr. Hugo Vallin shouldn't be here served as a co-defendant with the company. Why? Because it was raised in the particular of defense. There's an agreement that was made aside from the contract stating that initially, in order to prove good faith, because the company was not yet, established and the license was not obtained and the bank account was not open, as a proof of good faith, the founders of the company agreed to be on the tenancy agreement. And we have an email from Mr. Louet that confirms that once the license would be obtained, then the tenancy agreement will be only with the company itself. And the amendment hasn't been done despite the fact that the license was obtained. So then we had the list of regular issues that were mentioned by my opponent, Mr. Moore. And the financial difficulties were raised as per the terms of the agreement before the floods occur slightly, but not as an impossibility to pay, as a request to amend the payments because they were waiting for fundraising that were a bit delayed. And then the floods occur. And then it was a very complicated situation for the very simple reason that my clients realized that the business model was not working anymore. Why? Because the whole point, the whole idea of this concept was to use the light and the fame and the radiance of Dubai and DAFC to create a club of collectioners of luxurious cars. So if you cannot guarantee to your members that their favorite things on earth, which is a luxury car, is not protected because you're not in a waterproof, location, and floods can happen, and you cannot give any guarantee that if there's heavy rain again, everything won't be totally flooded, then the business model doesn't stand. And that is the heart of the issue here. It's true that it's force majeure because no one could foresee the catastrophe that happened. And I'm sure you remember it because we all remember it. And it was absolutely insane to see all those cars on the side of the highway. And it took months to take them away. So the damages even for the city of Dubai were tremendous. And that's why it echoes very clearly to our situation, because the force majeure that is actually materialized by those floods triggered a disastrous consequence for my clients. Their business was not working anymore. Like, there was no one to agree to continue to invest in a building with a parking lot that was flooded without any guarantee that it won't happen again. So the entire concept was not viable, while it works perfectly in Monaco and Paris. So that was, for me, the very fundamental point that I wanted to raise before we get into the technicalities.
Well, Monaco, I'm sure it's a different story, especially if it's next to the casino, because it's in a much higher place, and then the beach is downside like maybe 50 meters. So the water would find its way to the beach instead to the garage. I mean, it's not Monaco, it's Dubai, but well, say I don't want to say anything relating to the merit, but yeah, I think yeah, I think what you wanted to understand the nature of the business, and that required a certain arrangement for the location of this business, and then that should be reflected in the contractual situation between you and the claimant. You wanted to say
Right.
it's not as easy as straightforward. Mr. Moore tried to
Exactly.
introduce it. Well, it's okay. Well, unfortunately today I didn't have to worry about these details. Okay, this is for this nightmare is for another day. I would like to seek your consent and what called the agreed. So you mentioned something about the list of issues. Well, list of issues cannot be agreed unless you agreed on it. So that's why we call it agreed list of issues. You always can go back and forth with the claimant and then add your issue, the issue that you think it's going to be fit for the court for determination. And even if you disagree on it, you might have your own list of issue, and it's not a big deal. I don't know if you have appeared before this court before or not,
No.
Mr. Dre.
No,
But yeah,
it's the first.
the flexibility is still there. I mean, it's not too late. This is the purpose of having case management, so we can build the case accordingly.
but
We build it according to both parties' prospect. So we will allow a full presentation of the case of the case from both sides. Each side will be able to present his version of the story. Okay, and then plus evidence. I personally would like to explore the case. Sorry. I would leave that list of issue for you to deal with it, and first things to do after the case management, before even the production of document or the production of witness statement. So you try, Miss and Mr. Moore, try to agree on the list of issue for us as soon as today, tomorrow, after tomorrow, this week, as soon as.
Thank you, Your Excellency. If I could, perhaps I could just confirm that both parties have actually agreed that the list of issues. So we, to that extent, procedurally, we have agreed. We have agreed on that.
I thought she said we're not.
No, it was agreed. It's just that the claimant forgot to mention it. It's in the list of issues. But when he did his presentation, he forgot to mention it.
Yes. Okay, I understand.
And for me, it was a very crucial point that actually should be even considered first before getting into the core of the issues. That's the only point I wanted to make.
So you want the court to focus on the flood itself more than anything else?
No, to focus on the issue with the tenancy contract.
Not the flood.
The flood too, but for me, we have a first very clear problematic, which is that Hugo Valla and Laurent Buisine shouldn't be in front of this court because they shouldn't be part of the lease agreement.
Well, I mean, let me bring you to the first point. I mean, stage one, negotiation, mediation, and settlement still open for you until one day before the hearing, and maybe until the second day of the hearing as well. So I would always encourage you, if you can settle this amicably, it would be the great, and I will encourage you. And even if you need the court assistant, to have a professional mediator that can work with you both, we would help you with that. If you can find your own mediator, if the two counsel can sit together and resolve this amicably, I would encourage this personally, and this is what we do here in court. We try to promote party settlement. It's better than settling through. You're the judges now, and this is said you are the judges. If you can sit, you and Mr. Morgan and your teams, and discuss things and certain strategy, if you know what you want, what is the far ends interest of each parties, you might reach a settlement. So I would keep encouraging to reach settlement during the case management. Okay, I can see you're choosing not bad case management, because we usually have people who have very stretched case management, 9, 10, 12 months. So yours is around 6 months. So just 1 month beyond our anticipated limit, if you can shorten that. But for this, I need to look at your timetable. So the first things I would work with you is that the anticipated trial date and then trial length. And then I didn't think I need to remind you that expert is not granted. Each party has to make an application for the court to tell us why the court cannot determine the damages or the technical question, and why do we need to rely on expert and where the expert is going to take us. That is a separate application must be made by parties, and I hope that is kept in parties' mind. And if you'll bear with me, I'll try to open the case management again. This is the case bundle. This is the consent. Yeah, case management. You got it? I beg your pardon that my computer is slower than yours, but it will come soon for sure. Yes, here we go. So defendant shall file amendment statement of defense by 9th of September. That's very soon, like tomorrow. Oh, okay.
Yes.
I hope you're ready, Ms. Dre.
Yeah.
Okay.
Yeah. I submitted in advance to the claimant for review in order to actually anticipate the case management conference, which could be confirmed by the claimant.
Yes, that's correct. The amendment is agreed by the claimant.
Oh, you received it. That's great. Okay, this is
Indeed.
good. And this is good collaboration. We started good in this case. And you agreed the defendant would pay cost of the, okay, and you agreed on the amount as well, or only the principle?
That's only in principle at this stage, Your Excellency, because we obviously need to do some further work to amend our reply. And so we'll only know what our costs of the amendments are once that's completed.
That would be cost in the case then, yeah?
No, I think we've agreed that they will in principle pay the costs arising from the amendment to be assessed if not agreed. So we will seek to agree those once those are confirmed, and if they can't be agreed, then they will be up for assessment.
You might seek it independently from there.
Yes,
then
that's right.
Standard production by 13th October. Well, usually number 5 comes like a couple of days after number 4, like because once people receive the documentation, they would go explore them and see what's missing, what they want. So usually the request takes, I don't know, but if you're happy with that, Mr. Moore?
Yes, we're happy with that. We've discussed this with the defendants. I think it's anticipated that document production is going to be pretty light in general. So we don't foresee that there's going to be many requests outside of the standard production. And we already have a lot of the things that are likely produced in standard production, because many of the documents, most of the documents, I would say, have already been exhibited as part of the parties' pleadings.
If I may just...
I need to put you in awareness. Mr. Dre would ask for a lot of videos and footage for the flood, for the parking, I'm sure.
So on that, the questions that I have, because I couldn't actually got a straight answer, was the format to submit videos, Your Excellency.
Yeah, what you cannot get?
The format to provide videos, because we have videos that were made by one of our witnesses, and it will be part of the productions of documents and the evidence. And we just wanted to know how the court want us to submit those videos.
Well, I mean, see, first of all, you didn't have to submit the video for me for the court, straightforward. So you would like the videos would be, I mean, produced from one party to another parties, and then you can rely on it. Unless you need to present it before the court at the trial date, then otherwise you will need to give me a description, or the expert would deal with the video, and he would say, well, that's what you can see from the footage or the videos of this date at this minute. You can see 1, 2, 3, 3. Or you could produce, I mean, what called, well, we do have many video formatting, like we can upload into the case management system, so the court and the judges can see it at the hearing, during the hearing. But that is usually dealt with by expert. The most important person is dealing with the video is the expert, and then on that basis it's presented before court. But that doesn't mean that will not exclude you from presenting certain point.
Okay.
For the judges, for example, if you're expert of that expert, so if no one, like for example, with you, and what consequences the flood got on the project, you need to say, Mr. Judge, I need to show you what happened. You need to see this yourself. You didn't need an expert. Just with your bare eyes, you could decide in the matter. For example, then this is the video would be part of the documentation, and then the Alia with us here, the case manager, she would assist you how a video with the video or videos can be uploaded into the system. The system can take a lot, thousands of cases, hundreds of thousands of documentation, and hundreds of videos. Believe me, don't worry about that.
Thank you.
Yeah, and Alia is aware of the format as well, but we can accommodate where our system is like kind of flexible. We can't take so many formats into this system.
Thank you very much.
Yeah, but as I said, I mean, for you, because I said usually once you receive the standard of production on the 13th of October, and then there is another deadline same day. For just example, I'm telling you, if you are new into this case management, usually between you and your client, you said, oh, what's missing? You might need 1, 2, 3, 4 days to say, oh, that's missing, this missing. Okay, let's write to Mr. Moore. So Mr. Moore, we need 1, 2, 3, 4, 5. So usually, in most of the cases, we do stretch the deadline in number 5. But if you're happy with this, or as party would extend it between them in a good faith, then that shouldn't be a problem. If someone would like asking 2, 3, 4 more days, and shouldn't be a problem. But personally, I would extend it to the 20th, for example.
Okay. I mean, I think your advice is wise, but I'll see with the claimant what they want to do.
If you consent first time, you can consent second, third time as well. I mean, it's no big deal.
Thank you for your advice, Your Excellency. Certainly take that on board. And along with the other advice that you might have about the rest of the...
You know why we do this, Mr. Moore? Like, the more the case management is practical, is the less problems arise out of it. I tell you what, if Mr. Dre write to you on the 17th and said, oh, I need one more document, and they said, no, look at the case management, 13, we close the door. I got to seek direction. Then you call Mag, and Mag says, no, case management is done, and we can't provide you anything. So from that basis, usually the request is very important, and that does not cause problems. I mean, so that's what I would ask you. I mean, if you would like to review number 5 to make it just 22.
Of course. Thank you, Your Excellency. What I was going to suggest is that after we've taken on board all of your comments about the case management order today, Ms. Dre and I and our colleagues can go away and discuss and make any further amendments we consider to be necessary or appropriate based on your guidance. Thank you.
Number 6, objection request. So if So this is number 6. This is the straightforward request between parties to parties. Yeah, is that right? Or to court. This is the request to the court, or it's not clear from you.
These are between the parties.
This is between the parties. Okay. Then objection request to produce a financial file for 26. Okay, document production application 30th of October. Not bad. The usual timeline. See how much time you got between the application to produce and the witness statement. You got 20 days. 20 days. Not bad, but October 30th. Okay, I can assure to you, personally from October 30th to November 16, I'm not available at all because I know where I'm gonna be. So if there is a disagreement about if someone wants to compel that his counterparty to produce it through a court order, I don't know if 20 days would be sufficient before you produce witness statement, because the witness statement would, it's very hard to produce witness statement before the closing of the production. I might require you to revise this. Yeah, I might.
Okay.
Sure,
Yeah.
no problem.
Yeah.
Your Excellency, in your experience, how long do you think the party should provide for this step? Noting also your availability.
You could extend it even if it's overlap like with the expert evidence. You know what I mean?
Okay. Okay. So at least maybe end of November, 30th of November, maybe.
Yeah. 10 days is much better. Yeah, 10
Okay.
days safeguard. Yeah.
Okay. Sure.
And I, because I'm sure between 20th and 30th of November, I would be here. If the application is before me, I would decide it myself. Yeah. So see, proper production of document would lead to a proper witness statement, would lead to a proper expert report. If the expert and the witnesses have everything before them, then the statement is much better. The case is clearer as well.
But therefore, if
have you put deadline when each party should apply to court to appoint expert? I do not see it. I see expert evidence. He did directly with the expert evidence should meet and discuss. So that mean you would, okay, so unless you mean this expert in here is an technical expert from the internal unit of each parties, like it's not independent expert. You didn't mean independent expert here, yeah? It's like in a form of witness, technical witness. Is that right, Mr. Moore?
No, our expectation is that we would have an independent expert witness to provide evidence on the quantum and damages of our claim. The deadlines we've included there are agreed. I think it's both parties agree that they would like to engage independent experts, and these are the timeframes by which that evidence should obviously be provided, subject, of course, to the application that each party would need to make and the court's approval, as you've noted.
On the independent expert, it was not like I discussed this before over the phone with Miss Alanud, and for us it was a bit of a question still.
Who's Alanud? We didn't have Alanud.
Yeah.
Ms. Alanoud is my colleague, which
Oh,
is here on your screen, Your Excellency,
sorry, sorry.
who's discussed this
I thought
with
she had-
Straight.
Usually she would discuss this with the case management officers. Okay. So you're talking about submission of the expert report here. But I said, don't forget, you need to seek court permission to adduce expert evidence. Well, you need to convince the court that you really need that expert, that certain expert to deliver that certain technical opinion.
Yes, yeah, yes. Thank you, Actually, that's certainly understood.
You take that on board, please, in your next amendment.
Yes,
please.
of course, we will do so.
Yeah, for example, you could like you could do the deadline early second week, maybe the second week of November, maybe for the applying for court to adduce expert or something like that before 27. But again, it depends how long the expert would need some more time, and maybe you need to start earlier with the expert, where you need to apply to the court earlier than this.
Yes, thank you, Actually, I think certainly
maybe yesterday, Mr. Moore.
Maybe tomorrow. Might be more realistic.
Well, I tell you what, the court is usually are not flexible with appointing experts. You need to work hard to convince the court why you need expert, why you and your department, your lawyers, your witnesses, your factual witness cannot prove the case. You know what I mean? Usually, like you need to convince the court why you need expert. Honestly, I mean, I'm not saying it's a high threshold, but you need to do some work to convince the court to allow you bringing witnesses beyond the standard proof system. Okay. Trial bundle 3 weeks before trial. If you have witnesses, if you have experts, if you end up having experts, I think 3 weeks is ideal for the court to have the file before the trial. You don't know how nightmare reading expert report, Mr. Moore.
Yes, thank you. That's well noted, Your Excellency.
Reading this timetable, that's fine. Skeleton argument for clear days is fine. For skeleton argument. Pre-trial review, 16th of February. What is that? 16th February can be the first day of Ramadan, first fasting day, Mr. Moore. I guess let me double check with my calendar.
Sorry about that. Yeah.
We'll see.
But yes, this year it's in February, so it could be actually the first day. True.
We are obviously happy to accommodate your availability, Your Excellency, for the pre-trial review anywhere within the normal range of 4 to 6 weeks before trial.
I mean, if we need to change the trial date based on Ramadan because it might impact the calendar of
no,
the
but
case
I would just avoid the 16th because 16 would be the first day.
No, yeah, of
first
course.
day fasting. I'm sure I'll be hungry and angry. It would be difficult for you to talk to me. Maybe we can do it like 2-3 days, so when person gets used to fasting, you know what I mean?
Any dates that suits you is okay.
Yeah, I would say, yeah, 16th is a Monday, I guess. 16th is a Monday. I would say Wednesday or Thursday.
Maybe we could push it back one more week.
Push it 2-3. Oh, 1 more week. Even 2-3 days is fine. Pre-trial won't take much. So, and there any of you would be appearing from outside the country? So, for example, from Europe or London, or might be.
Not
Okay,
from the legal team, Your Excellency.
yeah, I mean, change 10 to 1 p.m. please, and try to make it 19th. Initially, let's agree to 19th February. Is that good?
It is. It is.
Yes, Your Excellency, all good.
Yeah, because 10 in Ramadan is the opening hour of the court, I guess, as well, and it's. Trial. So the 30th of, you're looking for 30th of March. Let's check my calendar. I have no issue with the 30th of March. And 2 to 3 days, that would depends on how many experts and how many witnesses you are allowed to rely on. Okay, that's all I can say about the case management. Is there anything you would like to bring before us today, Mr. Moore or Ms. Dre?
Yes. May I just ask if you think it could be, of course, if the claimant agrees, of any interest for, let's say, an efficient handling of the case to examine the question of the tenancy agreement at the preliminary hearings instead of everything together?
Okay, let's ask you for something else first.
I'm sorry.
Would you recommend in-person hearing or online hearing? I would encourage you to come to the court.
I'd rather come in person, yes, if
Mr.
possible.
Moore?
Yes, we are comfortable with an in-person hearing.
Yep. I think most of, even if you have witnesses, there will be a local witnesses here.
No, my witness will be through actually video link because they're in Paris.
Oh, they're in Paris. They could be in Paris. They could be somewhere else.
True, but supposedly they are based in Paris.
Okay. No, not big deal. But we still can do it in person. Like in courtroom, we can take any witnesses through online services, one witnesses or two. If one of them here, it happened, he's here, so he can come to the court. Yeah, so he would know about the hearing like 3-4 months prior to his arrangement, whatever. So yeah, no big deal. So let's Alia, let's hope that this case go in person hearing, and then we will see. And then you said you want to a determination of the a lease contract prior to the trial.
At the pre-trial, if possible.
What exactly you want to do? I didn't understand. I didn't get it.
So the lease, because we do consider that the issue related to the lease would have an impact on the entire case, because Laurent Buisine and Hugo Ballin would be or not be considered as party to the lease agreement. would it be possible to handle this issue prior to the main hearing?
Okay. I didn't claim understand you in full, but let's hear from Mr. Moore. Let's hear from Mr. Moore, then I come back to this.
Thank you, Your Excellency. Look, this is the first time that I'm hearing about this potential issue being dealt with as a preliminary issue before the main merits hearing. On that basis, I'm obviously not quite sure how to react, other than to say that if this is if the defendants want to make an application for the removal of the second and third defendants as parties to this proceeding, then it's obviously entirely up to them to make that application, and we'll respond accordingly. And perhaps even we may even be in a position to agree a timetable for that to be dealt with before the main trial. But unless and until my clients and I see that application, what's being asked for, the basis upon which it's being asked for, I really can't offer much other comment than that, Your Excellency.
Yeah, because once she said that, the first things come to my mind, she might be seeking immediate judgment application, but I don't think she's going that far. So usually you could go to immediate judgment application, but that judgment application or the strikeout that if you succeeded in law or in contractual argument, you could bring the case into an end before you go to a factual deliberation, and that is the situation. But I really don't. You need to double check what you want, Ms. Dre, first, and then whatever you want, you can apply to the court, and the court would. So before you apply to court, you could discuss with your counterparty if you agreed on something. If you bring it together, that is cheaper option. If he disagree with you, you can always approach the court for whatever you think fit for the better management of your case.
No, absolutely. But the point was not to make a distinct application. The point was just to see if it was not, let's say, a more efficient way or fast way to handle first the issue of the tenancy agreement, because it's an amended tenancy agreement that was not implemented, instead of, because for us it has a very great impact.
That's what I invite you to look at the rules of immediate judgment. It might help you. I'm not sure if that's what you want, but yeah, look at the rules of the immediate judgment.
Okay.
Or the early determination of the facts.
Okay.
Also, sorry, of the legal matters before facts, and then we deal with it.
Okay. Thank you, Your Excellency.
Yeah, I hear there is a disagreement between you related to the cost of the adjournment of the previous case management, but I hope that resolved already, or
no, it hasn't been resolved yet.
Not resolved. Yeah, and I have seen a written submission from both parties. Do you want the court to deal with it on paper directly, or do you want to now submit something already?
Personally, I think if my counterpart is okay with this, if the court can just, take its decision on the papers, that would be perfectly fine for me.
Some more?
Yeah, you have, Your Excellency, the parties' submissions are dealt with in some length. I'm more than happy to elaborate on those orally now, if that's something you would like. But otherwise, I think you have in front of you everything you need to make a determination of that application.
Yeah, it's not a big deal, I think. I mean, I think I'll deal with it on paper. Unless I will need further elaboration, I will write to you back to enlighten me in any certain point.
Thank you, Your Excellency.
Thank you, Your Excellency.
Pleasure. So we decided the trial date, trial length, it's 2 days unless there is an expert. We knew the pre-trial date now. You have a very reasonable timetable for case management. And again, I encourage you to try to settle this, to renegotiate the dispute between you and try to settle this case amicably. If you both, any of you need the court assessment in terms of mediation, then the court will assess you with that. I wish you all the best, and then we'll see you soon. Thank you
Your
for the
Excellency.
counsel for the team. Thank you very much.
Thank you very much, Your
Have a
Excellency.
good day ahead.
Thank you.
Have a good day. Take care.